Well, thank you all for coming and for attending the criminal justice reform session of our symposium today. My name is Michael JAHR. I am the Vice President for Outreach and Special Projects at the JAHR Institute. Over the last year, we've been very fortunate to be working with a coalition of organizations and individuals to look at what are some of the reforms that can take place in Wisconsin that can help us do a better job with our prison system, our reentry system, our revocation issues, and so on. One of the things we just heard about was that Wisconsin does not do well in terms of our tax structure. The same is true for our prison and jail system. We've got too many people in our system, far more than our facilities were built and designed for. We have too many people who are returning to the system. And so one of the things that this coalition has done over the last several months has been working on recommendations for Wisconsin for reform. We've covered everything from reentry and workforce issues to expungement to bail jumping and a number of other issues in between. And we're very fortunate to have with us some of the authors of that particular booklet and reform piece, as well as we have a number of copies of those at the back, so please help yourself to those at the end. One of the things that has been the result of the weather here is that we lost one of our panelists. So we're very fortunate to have with us somebody who was willing to, with about 15 minutes of notice, based on a text, say that he would be willing to fill in for that. So Jeremiah, thank you for filling in. We've got a terrific panel here today, actually encyclopedic knowledge of Wisconsin's criminal justice and correction system. And if there's a question that can't be answered by these three, then it can't be answered. Cecelia Klingele, who's shaking her head vigorously. Cecelia Klingele is an associate professor at the University of Wisconsin Law School, where she teaches courses in criminal law, constitutional criminal procedure, policing, sentencing, and corrections. In her spare time, she is also a faculty associate of the Franklin J. Remington Center, the La Follette School of Public Affairs, and the Institute for Research on Poverty. Professor Klingele's academic research focuses on criminal justice administration with an emphasis on community and institutional corrections. And that is a nutshell. I actually was looking at her bio earlier to glean some things and pull some things into the introduction. And I went through and it was just a very, very impressive full bio. And I thought, wow, how does one person accomplish all of this? And then at the very bottom, there's a little button that says, click more to see full bio. Then we have with us Tom Lyons from Right on Crime. Tom entered the legal field after receiving an undergraduate degree from the University of Illinois and a law degree from Marquette University. Congratulations on your basketball season so far. Yeah. Working in offices in Kewaunee and Sheboygan counties, Tom's law practice focused primarily on criminal defense, juvenile, and mental health law. He then switched to the world of public policy. I don't know if that's an upward or a downward to go from being a lawyer to, anyway, in the world of politics. He switched to the world of policy, starting as a legislative aide for a member of the Wisconsin State Assembly, going over to the Senate, and then for a brief time working for Governor Scott Walker before joining Right on Crime, which is a national organization addressing criminal justice reform issues from a center-right perspective. And then finally, Jeremiah, our last-minute fill-in. I'll just read directly from his LinkedIn bio here. Jeremiah is a policy liaison at the Charles Koch Institute, based in Washington, D.C. How long have you been there now, Jeremiah?
About a year.
About a year. And Jeremiah, prior to that, was with Prison Fellowship for about 3.5 years. He's a graduate of Liberty University, where he got his JD in 2016. So thanks to all of you. And Cecelia, we'll have you start off.
Well, thank you so much. It's a delight to be here with you and to have an opportunity to speak for 8 minutes, I am told, and I will try to time myself because law professors are not known for our brevity. To talk to you a little bit about some of the work I do and its relevance to some of the work that you do here in this building. As you heard in my bio, one of my primary research interests is the administration of the criminal justice system, and I focus particularly on community supervision. How do we punish people outside of jail and prison? A lot of our conversations around criminal justice reform focus on institutional corrections. How do we minimize the number of people who are in jails and prisons, and how do we reduce the amount of time they need to spend in custody? It's costly to confine people, both in terms of losses to the community and to families, and also in financial terms. What I think is important to remember is that while we have a number of people in this state, a growing number of people behind bars, as of last week, it was 23,406 people in our state prison system alone. That doesn't count our jails. It's also important to remember that the majority of people serving criminal sentences in our state and in states across the nation are not behind bars. Rather, they're serving sentences in the community. Last week, we had 65,445 people, and that's only actually adults, I'm not counting the juvenile population, serving sentences in our communities. Those sentences are for probation on the front end, individuals who weren't ordered to serve a term of custody at all following sentencing. And on the back end, those are primarily individuals serving terms of extended supervision following prison terms. A more limited number are also serving old parole sentences as well. We might think that community sentences are the opposite of custodial sentences, and we usually talk about probation as an alternative to incarceration. My work focuses on complicating that story a little bit, and on exploring the ways in which many times community sentences become custodial sentences, how that happens, and how we might prevent it happening in a more effective way. To that end, given the limited time, I want to focus just a little bit on some work that I've been doing recently. For the past 2.5, probably, Mike Nichols could give me a more effective measure of time, I think about 2.5 years now, in partnership with both the JAHR Institute and more recently with the Charles Koch Institute support, or foundation support. I've been able to do some research focused on community supervision here in the state of Wisconsin. As part of that research, what I've been able to do is get a snapshot of cases in which supervision has failed, where corrections is asking for individuals who are on probation or extended supervision to be returned to custody. And over a 3-month period, I've grabbed all the cases that headed toward revocation from 4 different locations around the state of Wisconsin. That's a sample of about 190 cases in which corrections began down the pathway of asking to revoke an individual. And in those cases, I've been able to review corrections summary of what supervision looked like, what rules were violated, and what was happening on the ground. In addition, I am still in the process of interviewing people who have recently been on or are currently on supervision in those areas of the state and a few others, and have talked to almost 20 people now who have recently been on supervision about their experiences. I'm hoping to talk to probation officers soon as well. And from those, what I can tell you is that supervision is complicated, and the ways of fixing it are as well. There are a few lessons that I think stand out for lawmakers. Some offer easy fixes, yay, I know that's what people like, and some offer much more difficult questions that I think policymakers need to engage with and try to answer if we're going to improve the quality and effectiveness of supervision in the state of Wisconsin. First, the easy stuff, because that's what folks like the most. It's important to know that our state authorizes very long terms of supervision, particularly on the back end of prison sentences. Our extended supervision sentences can extend for decades in some cases, and also long terms of probation. That is not true nationally. In fact, in many jurisdictions, terms of supervision are limited to anywhere from 1 to 3 or 5 years as a maximum custodial sentence. You might think that that seems strange. After all, if someone goes to prison, they can often go to prison for a longer period of time than that. Though not always, it depends on the crime of conviction. But in fact, the decision to allow someone, particularly on probation, to remain in the community is a decision that says we believe that someone can be adequately held accountable for criminal conduct without being confined behind bars. The ability of the state to hold someone accountable, to have them pay appropriate restitution, to engage in programming, things of that nature, can usually be accomplished in a fairly short period of time. And in fact, national statistics suggest that people who don't succeed on supervision, who fail and are revoked and returned to custody, usually do so in a very short period following their release from the sentencing court or their release from prison on the back end of a sentence. Typically, we see highest failure rates within 6 months, with diminishing rates to about the 3-year mark. That suggests that after a certain amount of time, probation and extended supervision may, instead of holding people accountable and assisting them in their entry into the pro-social community, in fact, be serving as tripwires. And certainly in the interviews that I've done with individuals on supervision, many of them echo that theme over and over again. None of them, maybe 1 or 2 exceptions, but very few people object to supervision or to being held accountable to rules, to having to report to their agents and comply with appropriate safety regulations. What they do object to is the ways in which the enforcement of these rules, which is often, from their perspective at least, arbitrary or inconsistent as their agents turn over very, very rapidly and frequently, the enforcement of those rules interferes with their ability to establish and maintain employment in particular, and familial connections in many situations. And as they go through supervision, there's an ongoing sense by individuals that once they have proved themselves compliant, there is an injustice and a difficulty that's presented by following the rules of supervision, with the loss often of other opportunities that might allow them to advance their lives and better support their families. So that's one thing to think about, is length of supervision and limits on supervision. And then the second that I would say is the harder one, and so I'll leave you with this question, because it's easy to fix limits on supervision. You pass a law. The harder issues are what we're providing people with. So many times we think of supervision as a 2-for-1. We're going to get surveillance of individuals to make sure they're not doing anything inappropriate. And we're going to provide them with services that they need in order to live a law-abiding life. Often in our state, increasingly, that's going to involve drug treatment for individuals with substance abuse disorders. It may involve mental health treatment. It may involve other kinds of counseling to assist people in overcoming past life stressors that may be connected to their current offending behavior. The challenge is delivering on that promise. When we continue the surveillance without providing the services, we often set people up for failure. And the conditions of supervision, often at the time of sentencing, you can predict people will struggle to comply with. Unfortunately, in our state, especially in rural locations, we often lack adequate means of providing people with the help that we know they need. Taking someone with an extended and substantial drug disorder, someone who is seriously addicted to opioids, and sending that person to a weekly NA meeting is not going to end well. We need more investment of resources in our communities if we're going to help those on community supervision succeed. And if we don't think that's realistic or possible, we need to rethink the conditions of supervision and which people are ending up in that status, if we want to be realistic about what we can expect people to do. And my time's up, so I'm gonna have to shut up now. Thanks.
So what I'm going to do is make a case for why criminal justice reform is a very important issue and should be to conservatives. And then I'm going to walk through the anatomy of a typical criminal case to point out certain areas that certainly need re-examining on a constant basis. So as conservatives, for those who aren't conservative, this will be boring for you. But as conservatives, we often have a very healthy skepticism of any type of government program. We look at it and we first question whether it's the proper role of government to engage in that behavior, which for the criminal justice system, there's no question. It's obviously a central role of, in particular, state governments to address crime, decide what's criminal, and how to address it after it's completed. But the second thing we conservatives usually look at is that program efficient? Is it approaching the problem in a way that gets the type of return that would be most reasonable, not only to the taxpayers, but to the people who are victims of the crime, and also to the people who perpetrated the crime. I mean, the goal of the entire criminal justice system is to correct past wrongs and try to prevent future ones. And so in that light, you have to look at every single step that goes into a criminal prosecution to decide, are we actually accomplishing those goals as a state? Or are there areas in which we can improve? The criminal justice system is no different from any other type of government entity in that it can be subjected to red tape. And I'm going to use the definition of red tape being that some rule exists for a reason that no one can remember anymore. I would attribute that to whoever said that, I can't remember. But because there's so many steps in the criminal justice system, there are many number of stress points where better ideas could come into play. So let's walk through it. First, what happens in a criminal prosecution normally is that you get arrested. After you get arrested, then you'll be brought in front of a judge or a court commissioner. At that point, they're going to determine bail. Now, the purpose of bail is really twofold. There are two components to it. One is a monetary component. According to our Constitution, according to state law, the purpose of the monetary component is to ensure future appearances at that court and that you would cooperate with the prosecution process. And the second is non-monetary conditions, where the purpose is to prevent future lawbreaking. The way that Wisconsin is somewhat unique and in somewhat a lot of ways ahead of other states. First of all, we don't have bail bondsmen. And so that removes a huge financial incentive to set bail amounts that might in turn be used to profit other people. But an area that might need addressing is the non-monetary conditions of bond. Normally what happens is there are standard conditions, and there's about 12 or so of those, and they don't have to be necessarily connected to any type of conduct in the case. So I'll give you an example. Let's say you got arrested for embezzling from the company that you work at. No, not good. But one of the standard conditions of bond is that you cannot consume any type of alcoholic drink. Now, is there any type of nexus between trying to prosecute someone for having what would otherwise be a very legal activity simply because you currently are facing the prospect of jail time or some type of punishment in the future? This becomes a big issue because one of the, if not the two largest criminal charges filed in the state are bail jumping. And bail jumping simply means that you violated the conditions of your bond. Where Wisconsin is also unique is that Wisconsin law determines bail jumping, the seriousness of the bail jumping charge, based on the underlying charge. And so what that means, going back to my embezzling example, is that I'm going to go ahead and assume that's a felony of some type. I mean, I don't think embezzling is actually a crime, but I think there's a number of felonies that could fall under that. So if, for example, you're charged with that, you're released, you're spotted in a restaurant having a drink with dinner, someone else who's familiar with your case sees you across the restaurant and then reports you to the district attorney, you then would be subjected to a felony bail jumping charge because the underlying charge is a felony. Now, let's throw another example in there. Let's say you get into a bar fight, as sometimes happens, and you get charged with a battery which is a misdemeanor. You get charged with disorderly conduct, also a misdemeanor. And you get charged with these things because you actually caused physical harm, probably as some contributing factor to the alcohol that you consumed. Same situation where if a victim were to spot you in a restaurant and then report to the DA that they saw you consuming alcohol, your charge would be misdemeanor bail jumping, not felony bail jumping. There has to be a connection between the actions that someone takes and the charges that the state ultimately files in order for the system to seem just to all the parties involved. The criminal justice system shouldn't, this is just one example, the criminal justice system should not be a game of gotcha and trying to pile on as many charges as possible. One final thought on bail jumping that I forgot. The reason why bail jumping is so popularly charged and why it should concern people is the underlying charge of bail jumping is relatively easy to prove. You know, there's only two elements. They have to show that you violated a condition of the bond and that you were under that bond. Very, very easy to prove, as opposed to, say, going back to my original example, embezzling, which has a lot more elements and requires the state to do a lot more work. The underlying charge of bail jumping in many instances can carry a more severe penalty than whatever the original charge was. So any number of ways could be looked at how to maybe correct this or finesse this. Are standard conditions of bond really a good thing? Should courts have more flexibility in determining what those conditions are? Should there be a different charging scheme where just because the underlying charge is a felony, maybe that shouldn't result in a felony bail jumping depending on how you violated the conditions of those bonds? So, going back to the anatomy, we've now passed the bail component. You're released. You're facing trial. 90, I think, I'm trying to remember the number, more than 80%, I might be closer to 90% of all criminal cases involve a confession. The number of cases that end in a plea deal are mid-90s, 95, 96, somewhere in that area. And so what then you're likely to face is the prospect of what Cecelia talked about. And that is you are facing one of three things. You're facing a fine, you're facing some period of incarceration, or you're facing some type of form of community supervision, whether that be probation or extended supervision or some combination of those three. And again, we run into a similar type issue that arises during bail jumping, because when you're placed on probation, you are subjected to standard rules. And the court would impose these. The court also has the option to add additional rules to the supervision. In addition to that, your probation officer has the ability to add rules and conditions. There is no requirement that the conditions of that probation actually in any way match whatever conduct you had been convicted of. In addition to that, how those rules are enforced can vary greatly from location to location. Probation officers are not required to be kind of pseudo social workers. So depending on who is physically sitting in front of you at the Center for Community Supervision can have a great impact on how well you will adjust on supervision. You can have agents who will provide no insight, no help, no guidance on how to comply with those conditions, and they can continue to impose new conditions. Or you can have a probation officer who says, okay, you're supposed to take anger management classes or something like that. Here at the local tech college, we have an offering. Here's the pamphlet. Here, we'll sign you up. You can't get transportation there. Okay, here's, the city has some type of program involving free transport, whatever. But there's no requirement that be done. Perhaps it should be looked at if there should be a uniform system of how probation officers should interact with their supervisees. Final thing, because my time's up. And I'm going to touch on it very, very briefly because I saw the schedule and I saw occupational licensures next, and so it kind of relates to that. Once you're actually off supervision, though, there are a number of what in the legal business they call collateral consequences to a conviction. And a huge number of those affect employment. Where Wisconsin could greatly benefit is the current law is a hodgepodge of seemingly meaningless distinctions between certain licenses and certain convictions. I'll throw one of my favorite examples out now. Any type of criminal conviction under statute would forever prohibit you from becoming a landscape architect in the state. Now, I'll be honest, I don't know what a landscape architect is. I really don't. But it seems a little harsh. It seems like the type of thing that maybe a 17-year-old convicted of a simple disorderly conduct maybe should not have to worry about that when he's in his 50s. Conversely, to be a law enforcement officer, you cannot have a conviction within 5 years prior to applying. So it creates strains of a 17-year-old, because we still prosecute 17-year-olds in the state as adults, getting a conviction, being eligible to be a law enforcement officer by the age of 22, but at the age of 50 not being able to be a landscape architect. The point of all this, because I promised I'd wrap up, the criminal justice system is like any other system. It needs to be reevaluated. It needs to be looked at continuously to make sure the goals of it are actually being met, to make sure that it all makes sense, and to look for the best outcomes for everyone participating in the system, and that includes defendants and victims. So with that, I'll wrap up.
Thanks, Tom. Well, thank you everyone for being here today. Glad that I could pitch in and fill in the third spot here. I'm just gonna kind of talk about three of the biggest conversations that are going on nationally related to criminal justice reform. Some of them will hit on some of the topics that Tom talked about, but just things that I think we need to be aware of as we're talking about Wisconsin-specific legislation and things that could improve the justice system in Wisconsin. So I think everyone in this room probably at least saw what we call the December miracle in DC, where the Senate passed the First Step Act and Trump signed it. And that was really a reflection. That piece of legislation was the first reform on the national level that we've seen in decades of the justice system and the Federal Bureau of Prisons. But really what it was a reflection of what we've seen work in other states like Texas and Georgia and South Carolina. The legislation just essentially reflected those reforms, and it kind of did three things. I'm just going to talk about what those three things are, and then I want to drill down on one specifically. It expanded and incentivized what I call a constructive culture in prison by allowing more prison programming that are actually going to help people acquire the skills, knowledge, and character change they need to be successful on reentry. It required that people be placed within 500 miles of their family whenever they're in a federal prison. And lastly, it tweaked some of our sentencing laws at the federal level to just ensure that the punishment imposed is a little more proportional to the harm caused by the criminal conduct. The one that I really want to focus on is the prison programming and talk a little bit about why that's important. This really reflects, I believe, the need in our country to help the 650,000 people that return every single year from federal and state prisons to overcome the cycle of incarceration. We see that over 80% of those currently are going to return to our state prison system within 9 years. We need to find a way to break that cycle and ensure that these people can become productive members of their community again. And we know some things we can do. We can expand programming in prison. We can allow more nonprofits in prisons to provide programming. We have a myriad amount of research that shows that mental health programming, substance abuse programming, faith-based programming, workforce development programming, all of it impacts recidivism in the double digits and helps people be successful upon reentry. And so I think this move by the federal government was important because as of right now, there is very limited programming in federal prisons, and the few programs that they do have thousands, a list of thousands of people that are in waiting to get into those programs. So we're not actually helping equip them to return. But I think the most exciting thing to see is that other states fueled this reform, but now different states are actually taking the same reforms and trying to adopt them within their jurisdictions. We see Florida, Pennsylvania, Mississippi have already taken steps to try and adopt similar reforms in their own states. And in Wisconsin specifically, something that Tom didn't mention, Governor Walker actually followed in these footsteps to try and implement more programming in prisons. I don't believe he actually got to implementation. Tom, you can correct me if I'm wrong. But we would love to see that continue because I think that we need to have programming in prison so that people can return and they can be productive members of their communities again. Because the frank reality is 95% of them are going to return. So we want them to return better than they were whenever they walked into the prison system. So the second thing I want to talk about, and a shameless plug for the new JAHR report, you'll see out there on the table, there is a Ban the Box Policies new policy brief out there. Grab this. This relates to the second conversation I want to have today. And it's just the conversation that people are having in the research space about the difference between ban-the-box policies and certificates of rehabilitation or employability. So the research that we have on these policies, because they were adopted by many, many states, within over a 10-year period, about 35 to 36 states adopted these types of policies. It was a very fast move because people wanted to ensure that people with a criminal record could access employment and could have meaningful employment. Well, some of the research has showed some positive and negative results. What we found is that when these apply to public sector jobs, it's great. It increases employment among the people that we want to help access this employment. But when it's applied to private employers, and we're forcing private employers to not look at criminal records, we've actually seen that this results in less employment for individuals with a criminal record. It results in discrimination against minorities. And I can talk more about that if anybody wants to ask that question. And it also resulted in more crime in some jurisdictions among the exact groups that it was meant to help. So the conversation has been, okay, this research shows that this is a mixed bag here. So what do we do? Ohio and North Carolina has adopted certificate of rehabilitation and employability statutes. And this is just a program where you can go back to a judge and you can prove to them, I've been restored, I'm a productive member of society again. And the state will actually give you a certificate that says this person has been rehabilitated. They are a good, outstanding member of their community. And these have actually been found to increase employment threefold among people who have a criminal record and have a certificate of rehabilitation. But it also has had a positive impact in housing, where it has improved housing by 24% among individuals who have this criminal record. So we talked a lot about employment. We can talk more about housing if anybody's curious, but there are massive barriers to accessing housing, and that's a feedback loop into employment, because if you don't have a place to live, you can't get a job. So I think this actually reflects a larger point that we need to keep in mind with the criminal justice system, is that we need to make sure the policies we're adopting are evidence-based and actually work. So instead of chasing a reform that is the hot topic or is the cool thing to do, we should actually study what's been adopted to see how it's impacting, because there are always going to be negative external consequences to any changes you make in the law. And then last, I just want to wrap up talking about bail reform or pretrial reform. Tom already mentioned the topics here in Wisconsin. We've seen California and New Jersey in the past year adopt sweeping reforms. This year so far, we've seen conversations here in Wisconsin. We've seen conversations in Tennessee, Kentucky, North Carolina, Texas, Mississippi. The list can go on and on and on about bail reform and about the situation of our pretrial system. And I think we all agree what we want to see. I call it the 3 M's. We want to maximize public safety, we want to minimize failures to appear, and we want to maintain individual liberty. I think no matter your political perspective, you can agree that's what we want to see in our pretrial system. And we want to reflect the principle of someone being innocent until proven guilty. And sadly, the current system's not doing that. People are being held for months and years. You can read the news stories. I'm not going to tell you about them, simply because they cannot afford to pay their bail bond. Whether you have a commercial system or you have a court-run system, people are being detained that are not a threat to public safety simply because they don't have the wealth to get out of the system. And people who do have the wealth are being released when they're a public safety risk simply because they can pay. I think that's the thing to keep in mind, is this is a coin. There's 2 sides of this coin. So there's some alternatives that have been discussed. I won't walk through all of them. Risk assessments. Actually, the journal Sentinel actually had a really good article on talking about the differences in opinions there and how they've been found to be effective at predicting risk, but also they've not actually resulted in the outcomes we wanted to see and the concerns about discrimination. And actually, Cass Sunstein from Harvard had a good article this week, so you could check that out if you're interested in more about risk assessments. And then 3 other potential alternatives we've seen is pretrial community supervision. A lot of states have been adopting those. That was a big component of New Jersey's reform. The big concern there is that urban areas, that works very well, but when you get to a rural community without a lot of resources, it's hard to do community supervision. And then two other things that have been talked about a lot is a speedy trial statute, just kind of encouraging the court system to more quickly bring people to trial to determine whether they're guilty, so that they're not sitting as an innocent individual in the jail system. And last but not least, there has actually been some states that have adopted what is called a presumption of release statute. So this actually already exists under our Constitution, but this is just a way to enshrine that in state law to say that when you're considering someone as a safety risk before trial, the presumption should be to release, not detain. So that's all I have to say.
One of the prerogatives of being the moderator is you get to ask the first couple of questions, and I actually have several, but I'll keep it to a couple. I lived in Washington, D.C. in the mid-'90s, and there was a real rise, basically an epidemic of crack use and murder rates, and that was not unique to Washington. It was happening in cities across the country, and a lot of the laws that we have on the books today are a result of what we were seeing at that time, and that was bipartisan support for those bills and so on. Can we pass these reforms that you're talking about? Can we make the changes that we're talking about and without returning to those days, in essence? Can we maintain public safety and pass these reforms?
I think I'm going to guess we are all going to say the same thing, which is yes, you can, though our reasons might be a little different. I think it's important to remember that we have a vast number of studies that show us that actually, although there's some connection between incarceration rates and crime rates, it's not as lockstep as you might think. In fact, there is a point at which rising incarceration can actually give rise to crime increases, particularly when we're talking about incarceration rates that remove large numbers of young men at the point where they should be home being fathers and supporting their families from our communities. We can decimate communities and create crime rather than resolving it. Earlier, Jeremiah said something, and I was going to quote you, and I didn't have my pen on me. But I think you made a point about something that I think it needs to be remembered. The criminal justice system should sort of adopt the Hippocratic Oath, and we should seek not to do harm. And when we intervene, we do so to hold people accountable for harms they have caused in our communities, with the goal of trying to restore our communities and make our state safer and just. In fact, many of the interventions we are currently using appear to impose harm and make bad situations worse. And so I think we should be constantly asking questions about what are the effects of our interventions and how do we ensure that what we are doing is not in fact worsening an already difficult situation.
Yeah, absolutely. I agree with that. And we have taken steps in the last couple of years in Wisconsin along that line. For example, I don't think it was last session, I think it was the session before, the state overturned a 60-some-year-old ban on the possession of switchblades. The reason why switchblades were prohibited in the state of Wisconsin was because in the 1950s, the movie West Side Story came out. This is a true story. And Wisconsin, like several other states, did kind of a knee-jerk reaction of banning them. And for a long time, it was a criminal offense to possess one. It kind of goes back to my red tape there. You have to constantly be asking, why does this exist? I mean, for a lot of criminal stuff, obviously we need prisons. Okay, there are people who need to be removed from society under certain circumstances in order to prevent recidivism. Murder is not a debatable offense. Okay, that everyone agrees that should be a crime. But it's when you get below that, when you start looking at a myriad of things. For example, I'll throw one out there that's still on the books. Vagrancy is illegal in the state of Wisconsin. It's defined as having no visible means of support, and that is shown by having less than $10 in your possession. It's a Class C misdemeanor. I don't think anyone has been successfully prosecuted for that in a long time, but still it remains a crime. And that's just another example, similar to the switchblades, why you have to always look at it. I mean, it's easy to take an epidemic and say, this is what the solution is, and we'll fix it through stiffer penalties or through treatment and diversion or whatever, but the need for a constant reevaluation is always going to be there.
Yeah, I agree with what both of my other distinguished panelists said, but I just want to throw out an example from the national perspective. Yes, Wisconsin can. Texas did it. Texas closed 8 prisons after its reforms, multiple juvenile facilities, saved billions of dollars. And guess what? Still saw double-digit declines in its crime rate, both property and violence. So it can be done. Other states have done it. Maybe those reforms won't work in Wisconsin, but there are other reforms that surely will to help fix the justice system.
There's a bill that's being considered or just been introduced here in Wisconsin addressing the expungement or expunction law that we have already on the books. We're an outlier again, or once again kind of unique in Wisconsin in the fact that if you want to go to a judge and get your record expunged, you have to do it at the time of sentencing when the judge has no idea whether or not you're going to get your act together and has no, and it's also a very chaotic time for the accused who may or may not have a lawyer who can tell him at that point that he needs to apply for expunction. Talk a little bit about whether or not, why reform might be needed in that area, and also there's a current age restriction. Should that be in place?
Sure. I don't think you give justice to how unusual Wisconsin's expunction law is. It is definitely an outlier in the fact that it's done at the time of sentencing, which makes absolutely zero sense, having been in courtrooms and argued for expunction. You're arguing about the future and what may happen in the future. And you know at that time that there's no way to predict the future, and you have no idea what's gonna happen. That we grant our judges in the state of Wisconsin, almost on all levels of the court system, a huge swath of leeway. They're allowed to consider most things as they see fit. There are not strict guidelines. Because of that, it's impossible to make a reasoned argument to the court that this person sitting next to you is definitely worthy of having that record sealed for public consumption. That right there, there's no common sense reason for it. And actually, I'll throw something else out there because I'm kind of on a weird Wisconsin law kick right now. Wisconsin allows expunction to be completely discretionary, except if you're a 17-year-old who's convicted of what is essentially the peeping Tom statute, the court must expunge your record. Why? I don't know, but it's in statute, so it has to be done. It would not take a lot of policy changes to vastly improve expunction law in this state. I mean, just very recently, for example, the Supreme Court ruled that the court can change the conditions of future expunction. So let's say you go in and the court says, okay, complete your probation, and then 2 years after that, everything's good, write me a letter and I'll expunge the record. But if for some reason, for a condition that wasn't actually laid out in court at that time, the court decides, nah, I take all that back. They're well within their rights to do that. They need guidelines. There needs to be a clearer policy of how to make right past wrongs. The age restriction in the state, I think, is 25. That's another issue of red tape in the criminal justice system. I'm not sure what possible reason you would limit it at 25. Why not 26? And if you can't answer that, then it really needs re-examining.
I think fundamentally about how do we set people up for success and not failure. There are so many ways we can tackle this. I mean, part of it is looking at just the big numbers. Does everyone currently in jail or prison need to be there? If they don't need to be there, why are they there? And do we have alternatives? There's a good amount of research suggesting that many individuals who come in contact with the criminal justice system, particularly for the first time, will never have a contact with that system again. Many times we make the mistake of over-programming those individuals, which we now know in many cases actually increases the risk that they will continue to have system contacts, rather than letting them go and leaving them alone. There are all sorts of internal reasons why we don't like to let go of our lowest risk people. In part, from a systems perspective, they're the nicest people. They follow the rules and they pay their bills. And so if you're a probation officer, you don't want to make those people go away. They're what make your day bright and happy, right? And we see around the country that frequently efforts to to get rid of sort of low-hanging fruit, people who don't need our interventions, are met with some resistance from those within the system. But in fact, doing that then lets us focus much more energy and many more resources on meeting the serious needs of the people who need it in our system. And that does often mean forging connections, and usually community supervision ends up being the primary connection point, right, between institutional corrections as people come back into the community. And I think the question that Tom raised, how do people see their role? And not just how do they see their role, but what resources do we give to community corrections to be of assistance to people rather than handing them a list and saying, good luck, go find a treatment program that meets my requirements? How do we help them connect individuals who often are lacking some basic organizational skills and the ability to follow through in many ways to do that work to help people succeed? And I think part of it is we first have to look at our system and say, where do we let go of people who don't need to be here? Do we have sanctions short of supervision that we can impose? Freestanding community service sanctions are an option. We give people community service and we say it's part of your probation, but there's no reason why we can't just make people do community service and then they're done if we think that's a sufficient way of holding them accountable. Sometimes for some people who have resources, financial penalties can be used more robustly. All of those things don't let people get away with crime with no consequence. They hold them accountable, but they let us focus our more limited system resources on the people who need them more.
And I think one of the biggest barriers to this tension that we feel of wanting to make sure we're helping those who are incarcerated, but also ensuring public safety, one of the biggest barriers is lack of information. A lot of justice systems, Wisconsin does not stand out here as different. We don't know what's going on in the system. We don't know how it's working because the data doesn't exist. Most states do not require collection. Most states do not require transparent reporting. And we need to improve that because that provides not only the ability for internal government actors to analyze what's happening, but also outside groups, researchers at universities to analyze what's happening and figure out what works. And we need to do more of that. As I mentioned earlier, evidence-based policies are the way to move forward and the way to make sure that our justice system is effective. And then just another minor thing that I want to make note of, I think we don't want to leave out community solutions and community programming as an option here. There are a lot of nonprofits out there doing great work. And one of the biggest things I see when I talk to these groups is that they don't even know what the organization across town is doing, how they can collaborate with them. Because every group has a comparative advantage, but the problem is they don't know that each other exists, so they can't collaborate. The one that does really good with resume workshops can't collaborate with the one that does better with housing because they don't know they exist. So making those connections in a lot of jurisdictions, Louisville stands out as a great example. They have actually gotten together, every organization that touches the reentry space, and I think Milwaukee has a reentry board as well, getting together, talking about what they're doing. So making sure that organization A says, oh, you need help with housing. Okay, organization B is the place you should go. Making sure those connections are being made. Because government's not always the best solution, but government needs to be a partner in helping these community solutions be effective.
Well, very good. That about wraps up our time, but I'm sure Cecelia, Jeremiah, and Tom would be available afterwards for questions and discussion. I just want to point out, too, that we do have additional publications, documents in the back, the aforementioned solutions for Wisconsin. We have an expungement study called Black Robes and Blue Collars. Have a brand new policy brief on banning the box and whether or not that's working in the places where it's being implemented, and a report called Unlocking Potential, which looks at a number of the issues that we discussed today. So thank you, panelists, for your time.